learners, welcome to this course on gender sensitization, society, culture and change. Today we will be discussing on implementation of Law 2, Prevention of Domestic Violence Act 2005. So now you have understood the definition of various terms given in this legislation. Now you have also discussed the duties and powers and functions of the protection officers, service providers and the government. Now we will be talking about procedure for obtaining orders or relief. We have discussed that you can have certain orders or relief under this legislation. So how will you ask for that relief? So what is the procedure for obtaining that order or relief is given in section 12. Application to magistrate, as we have discussed that the magistrate is empowered to issue these orders. So an aggrieved person or a protection officer or any other person on behalf of the aggrieved person may present an application to the magistrate seeking one or more reliefs. Depending on the case to case, you can ask for one relief or you can have one or more reliefs also, provided that before passing an order on such application, the magistrate shall take into consideration any domestic incident report received by him from the protection officer or the service provider. We know that this domestic incident report is prepared by the protection officer or the service provider and they give it to the magistrate. The relief sought for under subsection 1 may include a relief for issuance of an order for payment of compensation or damages without prejudice to the right of such person to institute a suit for compensation or damages for the injuries caused by the act of domestic violence committed by the respondent. Provided that where a decree for any amount as compensation or damages has been passed by any court in favor of the aggrieved person, the amount, if any, paid or payable in pursuance of the order made by the magistrate under this act shall be set off against the amount payable under such decree, and the decree shall, notwithstanding anything contained in this CPC or any other law for the time being in force, be executed for the balance amount, if any, left after such set off. So if you have been provided compensation or monetary relief by the magistrate order, then the remaining part can be asked by CPC. So it is not that again and again you give the same amount. So if you have given 5,000, maybe 3,000 has been asked by the magistrate, and the CPC they have given 5,000. So 3,000 will be deducted from that 5,000 amount, and then the respondent will pay another 2,000. It is not that once you have paid 5,000 or 3,000 and then again you have to pay 5,000 under CPC. Every application under subsection 1 shall be in such form and contain such particulars as may be prescribed or as nearly as possible thereto. Then the magistrate shall fix the date of hearing, which shall not ordinarily be beyond 3 days from the date of receipt of any application by the court. The magistrate shall endeavour to dispose of every application made under subsection 1 within a period of 60 days from the dates of its first hearing. A very important provision for speedy justice. Service of notice is mentioned in section 13 of this legislation. A notice of the date of hearing fixed under section 12 shall be given by the magistrate to the protection officer, who shall get it served by such means as may be prescribed on the respondent. So the protection officer has the duty to get this served to the respondent and on any other person as directed by the magistrate within the maximum period of 2 days or such further reasonable time as may be allowed by the magistrate from the date of its receipt. A declaration of service of notice made by the protection officer in such form as may be prescribed shall be the proof that such notice was served upon the respondent and on any other person as directed by the magistrate unless the contrary is proved. Counseling has been provided in section 14. The magistrate may at any stage of the proceeding under this act direct the respondent or the aggrieved person either singly or jointly to undergo counseling with any member of the service provider who possesses such qualification and experience in counseling as may be prescribed. So, counseling is an integral part of this legislation. Where the magistrate has issued any direction under subsection 1, he shall fix the next date of hearing of the case within a period not exceeding 2 months. Then you can get an assistance of welfare expert under section 15. If any proceeding under this act, the magistrate may secure the services of such person, preferably a woman, whether related to the aggrieved person or not, including a person engaged in promoting family welfare as he thinks fit for the purpose of assisting him in discharging his functions. Proceedings to be held in camera to protect your dignity and privacy rights. Under section 16, if the magistrate considers that the circumstances of the case so warrant, and if either party to the proceedings so desires, he may conduct the proceedings under this act in camera. Right to reside in a shared household. You want to reside in that shared household. So, under section 17, you can ask. Notwithstanding anything contained in any other law for the time being in force, every woman in a domestic relationship shall have the right to reside in the shared household whether or not she has any right, title or beneficial interest in the same. So, we have already discussed that you may have a title, you do not have a title, you may have a right, you do not have a right, but you have a right to stay in that or right to reside in that shared household. The aggrieved person shall not be evicted or excluded from the shared household or any part of it by the respondent save in accordance with the procedure established by the law. Protection orders are given in section 18. The magistrate may, after giving the aggrieved person and the respondent an opportunity of being heard and on being prima facie satisfied that the domestic violence has taken place or is likely to take place, so it is a preventive legislation also, pass a protection order in favor of the aggrieved person and prohibit the respondent from committing any act of domestic violence, aiding or abetting in the commission of acts of domestic violence, entering the place of employment of the aggrieved person, or if the person aggrieved is a child, a school or any other place frequented by the aggrieved person. So, this is a very protective legislation wherein you will not be allowed to enter in a premise where the magistrate has a reason to believe that you can harm the person. Attempting to communicate in any form whatsoever with the aggrieved person, including personal, oral or written or electronic or telephonic contact, even using social media. Alienating any assets, operating bank lockers or bank accounts used or held or enjoyed by both the parties, jointly by the aggrieved person and the respondent or singly by the respondent, including her sridan or any other property held either jointly by the parties or separately by them without the leave of the magistrate. So, you cannot sell off the property, you cannot operate the bank locker, you cannot take out money from the bank accounts, you cannot sell off any property which is jointly owned or singly owned or has a right of that lady or has not a right, do not have the rights of the lady, because the court will decide whether the lady has the right in that or not. So, you cannot alienate any asset, you cannot sell any asset. Causing violence to the dependents, other relatives or any person who give the aggrieved person assistance from domestic violence, committing any other act as specified in the protection order. Residence order is mentioned in section 19. While disposing of an application under subsection 1 of section 12, the magistrate may, on being satisfied that domestic violence has taken place, pass a residence order. So, the magistrate can pass a protection order and now the magistrate can also pass a residence order. restraining the respondent from dispossessing or in any other manner disturbing the possession of the aggrieved person from the shared household, whether or not the respondent has a legal or equitable interest in the shared household. Directing the respondent to remove himself from the shared household if the safety is in question. Restraining the respondent or any of his relatives from entering any portion of the shared household in which the aggrieved person reside, a protective legislation. Restraining the respondent from alienation or disposing of the shared household or encumbering the same. Restraining the respondent from renouncing his rights in the shared household except with the leave of the magistrate, or directing the respondent to secure some same level of alternate accommodation for the aggrieved person as enjoyed by her in the shared household, or to pay rent for the same if the circumstances so require, provided that no order under this clause B shall be passed against any person who is a woman. So this legislation, protects the woman. So this order cannot be passed against a woman. Alternate accommodation is very important, if your life and your dignity is in question. So the magistrate may decide on case-to-case basis and ask also for alternate accommodation, and that alternate accommodation has to be at the same level or as per the same living standards of the shared household. The magistrate may impose any additional condition or pass any other direction which he may deem reasonably necessary to protect or to provide for the safety of the aggrieved person or any child of such aggrieved person. The magistrate may require from the respondent to execute a bond with or without sureties for preventing the commission of domestic violence. So this is also very important, that you can have a bond or surety from the respondent. An order under subsection 3 shall be deemed to be an order under chapter 7 of the Code of Criminal Procedure and shall be dealt with accordingly. While passing an order under subsection 1, subsection 2 or subsection 3, the court may also pass an order directing the officer in charge of the nearest police station to give protection to the aggrieved person or to assist her or the person making an application on her behalf in the implementation of the order. Every time we were saying that the protection officer, the service provider, will be forwarding a copy to the local police station. So this is very important that the service provider and the protection officer informs the local police station or the nearest police station so that the police station can give protection to the aggrieved person or assist her. By making an order under subsection 1, the magistrate may impose on the respondent obligation relating to the discharge of rent and other payments having regard to the financial needs and resources of the parties. The magistrate may direct the officer in charge of the police station in whose jurisdiction the magistrate has been approached to assist in the implementation of the protection order. So protection order has to be respected by the parties, and if there is any problem while implementation, the magistrate can direct the officer in charge to ensure that the protection order is implemented. The magistrate may direct the respondent to return to the possession of the aggrieved person her freedom or any other property or valuable security to which she is entitled to. Monetary relief is given under section 20 of this legislation. While disposing of an application under subsection 1 of section 12, the magistrate may direct the respondent to pay monetary relief to meet the expenses incurred and losses suffered by the aggrieved person and any child of the aggrieved person as a result of domestic violence, and such relief may include but not limited to. So welfare legislation is always, exhaustive. It is not limited. So the loss of earning, the medical expenses, the loss caused due to the destruction, damage or removal of any property from the control of the aggrieved person, the maintenance for the aggrieved person as well as her children, if any, including an order or in addition to an order of maintenance under section 125 of CRPC or any other law for the time being in force. So, it is an exhaustive list. The monetary relief granted under this section shall be adequate, fair and reasonable and consistent with the standard of living to which the aggrieved person is accustomed. A very important point. The magistrate shall have the power to order an appropriate lump sum payment or monthly payment of maintenance as the nature and circumstances of the case may require. The magistrate shall send a copy of the order for monetary relief under subsection 1 to the parties to the application and to the in charge of the police station within the local limits of whose jurisdiction the respondent resides to have it implemented. The respondent shall pay the monetary relief granted to the aggrieved person within the period specified in the order under subsection 1. Upon the failure on the part of the respondent to make payment in terms of the order under subsection 1, the magistrate may direct the employer or a debitor of the respondent to directly pay to the aggrieved person or to deposit with the court a portion of the wages or salaries or debt due to or accrued to the credit of the respondent, which amount may be adjusted towards the monetary relief payable by the respondent. A very important provision: if you do not abide by the monetary relief order and you do not pay that amount, then the magistrate can also ask your employer, your debitor, and can also attach a portion of your wage or salary and pay off to that lady. Custody order is given under section 21. Notwithstanding anything contained in any other law for the time being in force, the magistrate may at any time or at any stage of hearing of the application for protection order or any other relief under this act grant temporary custody of any child or children to the aggrieved person or the person making an application for her behalf and specify, if necessary, the arrangement for visit of such child or children by the respondent. So again, a very proactive legislation where the legislators have also thought about custody order for children. Provided that if the magistrate is of the opinion that any visit of the respondent may be harmful to the interest of the child or children, the magistrate shall refuse to allow such visit. So case to case basis, the magistrate will see the merits of the case and decide accordingly. Compensation order is given in section 22. In addition to the other reliefs as may be granted under this act, the magistrate may, on any application being made by the aggrieved person, pass an order directing the respondent to pay compensation and damages for the injuries, including mental torture, emotional distress caused by the acts of domestic violence committed by the respondent. Then the magistrate has the power to grant interim and ex-parte orders. Under section 23, interim is for the time being and ex-parte is, when you are just not hearing the other side. So just by hearing one side, you decide and pass an order. In any proceeding before him under this act, the magistrate may pass such interim order as he may deem just and proper. If the magistrate is satisfied that an application prima facie discloses that the respondent is committing or has committed an act of domestic violence, or that there is a likelihood that the respondent may commit an act of domestic violence, he may grant an ex parte order on the basis of the affidavit in such form as may be prescribed of the aggrieved person under section 18, section 19, 20, 21, or as the case may be, section 22 against the respondent. To give copies of order free of cost, this is mentioned in section 24, a very important provision. The magistrate shall in all cases where he has passed an order under this act order that the copy of such order shall be given free of cost to the parties to the application the police officer in charge of the police station in the jurisdiction of which the magistrate has been approached, any service provider located within the local limits of the jurisdiction of the court, and if any service provider has registered a domestic incident report to the service provider. Appeal can lie under section 29 of this legislation. There shall lie an appeal to the Court of Session within 30 days from the date on which the order made by the magistrate is served on the aggrieved person or the respondent, as the case may be, whichever is later. Chapter 5 talks about penalty for not discharging duty by the protection officer. Section 33 is very important. In this, if any protection officer fails or refuses to discharge his duties as directed by the magistrate, because we have seen that the protection officer is duty bound to do certain things. So if he refuses or fails to discharge his duties as directed by the magistrate in the protection order without any sufficient cause, he shall be punished with imprisonment of either description for a term which may extend to 1 year, or with fine which may extend to 20,000 rupees, or with both. Because protection officer has been entrusted with lot of faith, lot of commitment, so it is expected that he or she is doing her duties. Cognizance of offences committed by a protection officer is mentioned in section 34. No prosecution or other legal proceeding shall lie against the protection officer unless a complaint is filed with the previous sanction of the state government or an officer authorized by it in this behalf. Protection of action taken in good faith is mentioned under section 35. No suit, prosecution or other legal proceeding shall lie against the protection officer for any damage caused or likely to be caused by anything which is in good faith done or intended to be done under this act, or any rule or order made thereunder. So if you act in good faith, you are a bona fide person, then you will get the protection under this law. In the end, I would just like to say that we have seen a lot of orders which a magistrate can pass depending on case to case basis. So it is not that all the orders will be passed by the magistrate in every case. Whenever a case comes up before a magistrate, then the magistrate has powers to pass orders. And sometimes it does happen that people even do not know what kind of order or what kind of relief they should ask for. So there comes the role of the service provider or the protection officer, because they have certain duties, and if the protection officer does not follow their duties, then they can be also penalized under this legislation. In the end, I would just like to tell you all that this is a very proactive legislation, a preventive legislation, wherein on the basis of the merits of the case, the magistrate has the power to decide about the orders, to decide how much, if at a prima facie, if as a magistrate he or she feels that this is a case of domestic violence, then the magistrate can act, and the magistrate and the protection officer and the service providers will be provided if they act in a bona fide manner or they act in good faith. Thank you for listening and seeing and understanding the different provisions of Domestic Violence Act, and I hope that now you know the legislation well, you know different provisions related to this legislation, and you know that whom to contact in case of domestic violence. So if there is a case of domestic violence, you have to contact your service provider, you have to contact the protection officer, and you can also file a complaint at the local police station. Thank you all. Have a great day.